my lords, I got to my proposition 7. There's no doubt the mudstone in their title has a common character, and that's all we're claiming. But we have only ever demonstrated an intention to take the mudstone that's within our forests. It's got nothing to do with the registered title. It's got to do with what we have objectively demonstrated by what we've done on the ground. It doesn't matter whether we had title to the surface or not.
And is that reflected in the judge's order?
Yes,
I haven't studied it in detail.
Well, it's not reflecting the order because this is a second ground for supporting her judgment. You don't get to adverse possession.
You're of course quite right. I should have said in her judgment.
Yes. She says we have acquired adverse possession of the mudstone in the forested areas.
Right.
And of course we haven't acquired adverse possession of any mudstone outside the forested areas because we haven't evinced an intention to do anything with that mudstone. It's just the mudstone within the forest that we use as if it's our own.
Well, you say, of course. I must say, I wasn't entirely clear about that. I mean, I thought the argument might have been that the activities you had carried out in relation to the mudstone in the forested areas was sufficient to show an intention to occupy all the mudstone underlying all of the titles in issue.
Oh, gosh, no.
No, well, also a related point is, I mean, this may go to the map we still haven't seen on a large scale, but I mean, how much of the land we're talking about is forested? My understanding was most of it.
All of it. It's
all of it?
Well,
if all of it, then what's the difference between these two formulations?
I mean, when we say forest, there isn't necessarily a tree on every square inch.
No, of course not.
But it has all been used by the Forestry Commission and after the Forestry Commission by Natural Resources Wales as part of its statutory function of promoting commercial growth of wood.
And what about the plots which were said to have buildings on? I mean, was that just all ancient history, or the cottages and things like that?
Those aren't plots that belong to us or have been allotted to us. Those are plots that belong to other people and now have houses and so forth in the town. And the purpose of taking you to that was to demonstrate that the allotments that were made to private individuals can't have been just of the surface. We weren't saying that we are successors to those individuals. We're not. The question under the Act was, were the allotments, which were in the same terms to everyone, were they just of the surface for cultivation, or were they of everything underneath subject to the mineral reservation? The reason I took you to the ones in the towns was to show you that those ones, at least, must have been everything underneath. And because the terms of the allotments were the same for our land, which were fields, they must have included everything underneath too. We're certainly not claiming adverse possession of houses in the town of Clonard. What we're claiming is adverse possession of the mudstone underneath the parts of the land that we have used for our statutory function. So we're now on a separate question, which is, if on the A titles the mudstone was reserved, or if on the D titles the mudstone was reserved, have we, by what we have done in the forest, acquired adverse possession to that mudstone stratum insofar as it is bounded by the forest? would be an extravagant and ridiculous claim to suggest that we'd acquired title by adverse possession to mudstone outside the forest.
I'm sorry, I thought you just said all your land is forest.
Yes, but the claimant's title to the mudstone extends outside the forest to land that belongs to third parties.
Yeah, I see.
So the claimant's title to the mudstone, or in their case, includes all the mudstone under those allotments in Llanelloes. We haven't got adverse possession of those.
I see.
The individual owners of those houses might have adverse possession of those, but it's not us.
It'd be worrying if they didn't.
Well,
for them at any rate.
well, absolutely. And that's one of the reasons why the construction of the Act and the awards can't be right. It can't be right that the awards only allotted the surface so that those cottagers had to wait for 20 years until they got adverse possession of the mudstone.
So, Mr. Warnock, I'm just looking at the judge's conclusions, summary of conclusions. I think I've now understood something which I hadn't really picked up before. This is at 194 of the judgment. So the point about forested area is that in expressing the conclusions the judge reached in 194 1 and 2,
Yes.
that's a conclusion about the claimant title. So it isn't in fact only limited to the forested areas, and that's why the forested areas aren't mentioned in 1 and 2, because it's saying that the claimants do not have title to the mudstone.
Yes, that's right.
Whereas in 3, if that conclusion is incorrect, you have established, or your client rather, has established that it's the surface owner, insofar as you're the surface owner of the relevant forested area.
Yes.
And that's the distinction you're talking about.
That's absolutely right, and that comes from paragraph 170 of the judgment. These are uses that an occupying owner of the forest might expect to make of the mudstone. They're like the paving in Thorpe and Frank. Defendant has also been dealing with this land, that's the land within the mudstone within the forest, in the way that an occupying owner would for well over 12 years. And at 169, she says, importantly, this intent will be manifest as regards the whole forested area.
So was this business about wind turbines? They were going to be built in part of the forested area?
They were, yes. Well, it's the Cambrian Mountains. There are likely to be wind turbines in. And you have to look at this in a practical way. The authority for that is Robertson Swangrove, which is at tab 49 of Authority Bundle 3. And if you go to paragraph 63 of the judgment, this was the case that involved about 20,000 acres of tidal foreshore in the in the estuary in South Wales. If you just read for yourselves paragraph 63 and 64, you wouldn't be so kind. That's the principle we're relying on.
Yes.
It's all about taking a practical view. You look at acts of possession on part, and you ask whether there's a common character to the locality. If yes, then the reasonable inference is you're in possession of the extent that you have manifested an intention to take possession of. Now, we've never claimed adverse possession of any of the mudstone outside the forested areas because we've never manifested an intention to take possession of stone outside the forest areas. That belongs to the claimants, or it belongs to the adverse possessors of that land. It's not us.
Is that reflected? I'm sorry, I haven't looked at this recently. In your pleaded case, I mean, is that
Well,
how it's put?
The pleaded case against us was that there were reserved materials under our titles.
Yes.
And our pleaded response was we had acquired adverse possession of those materials. None of this is new. It all goes back to Jones and Williams, and Baron Park's judgment is the origin of the expression common character of locality. That was a Welsh dispute too. That was two farms separated by a stream with a fence, and the question was whether you could deduce evidence of ownership of the fence further down to show that the fence was a continuation of that fence and represented the boundary. Answer, yes. Common character of locality. Principle 8. An action to recover land, formerly called an action for ejectment, is not an action to eject an occupier. My learned friend says, how can I eject you from a solid? Wrong question. It's a wrong question because it misunderstands the legal history. Action ejectment is an action where someone who has a right to a legal estate complains that he is being kept out of possession. It is the being kept out of possession that is the ejection in ejectment. In the old cases, it's the fictional tenant, Mr. Doe, who's tried to get get into possession and then been ejected by the person who is in possession. I turn then to the grounds, but before I do so, it's worth reminding ourselves that this is the Court of Appeal. The question is not whether, on the evidence, you might have reached a different view from your judge, different view from the judge. Not your role, you haven't heard the evidence. As Lord Justice Lewison once said, the trial is not a dress rehearsal, it's the first and last night of the show. Primary findings of fact, evaluation from those facts, and inferences to be drawn from them are matters for the trial judge. The question for you is whether the judge made an error of law, or whether her primary findings could not be justified. Her primary findings could not justify the conclusions that she reached. So ground 4 is in the core bundle, I think at page 10, decimal 1. The learned judge erred in law was wrong to hold that digging into mudstone to construct a road or track, to construct ramps, to allow harvesting, to extract material from a quarry or borrow pit, constituted adverse possession of the entirety of the claimant's land, beyond that directly under those locations, being either the subsoil of the defendant's specific title where the act took place, or the subsoil of defendant's contiguous titles, and or that digging into mudstone to construct a road or track, to construct ramps to allow harvesting, constitute adverse possession of the subsoil at all of the subsoil below the level of actual interference. Well, that's not all that the judge relied on to decide that we had acquired title by adverse possession. Go to the judgment in the core bundle. At paragraph 67. She starts with the roads. And we'll come back in a moment to look at the title plans so you can see exactly how many roads there were that had been constructed. We go over to 72. She concludes that in virtually all cases the roads would have been widened and upgraded since the date of the acquisition. Plenty of evidence of that. Indeed, some of the evidence came from the appellant's own witnesses. And then 74, they're about 15% of the total area. And 78 to 80, she deals with the borrow pits and the other things we'd done with the mudstone. Then 81 and 82, the wind turbine and the telecommunications mast. There's no appeal against any of those primary findings of fact. That is what we had done. And she also found that we had manifested our intention to take possession of the bits between the roads by planting trees in it with roots that would go down into the mudstone. Well, they can't get to the mudstone if the trees are there. It's like putting a lock on the gate.
Where is that?
I'm sorry, my lord, I didn't hear.
Where is that in the judgment?
That isn't it. That was my comment. In the judgment, the reliance, the planting of trees as a manifestation of the intention to take place of the whole is at 169. And my own friend relied on the underground mining cases. Well, look, if you've got a seam of coal that extends over 90 acres and you just nibble at two of them, of course you're not going to be in possession of the whole seam. You might be in possession of the whole seam if the only way you can get to it is by drift mining, meaning that you've got the side of the hill and the only way you can get to the seam is from one side of the hill by cutting into it at a horizontal level. Someone who cuts into it at that horizontal level might be manifest an intention and be in possession of the whole seam if there's no other way of getting to it. But ours isn't an underground mining case. We've exposed the mudstone to the surface where we have cut into it to build our road. And we have stopped the appellants from getting to the rest of it by planting trees on top. How we are taking a practical view, can it be said that we have not been in possession of the whole of the mudstone under our forests for at least 50 years? Paragraph 60 of their skeleton, the appellant suggests that the judge didn't deal with intention. And even if she had, the evidence goes against us having any intention to deal with the stratum of mudstone in the way that an owner would. There's plenty of evidence that we were dealing with it in the way that an owner would. That was agreed in cross-examination of their expert. We were doing everything that an owner of the mudstone would do, apart from building buildings for mining. And she does deal with intention. She deals with it at paragraph 169 of her judgment. As I said this morning, there's an interesting question as to whether, if there's a seam of coal or something underneath, it's probably a bad example because coal is statutorily vested in the Coal Authority, but there's an interesting question if something valuable is underneath, whether we've acquired the mudstone all the way down to and including that material, or whether only the stratum of mudstone. But it doesn't matter because we're not claiming it. Yeah, I can see if you occupy the basement of a house, you might not be in possession of the land underneath. And if you occupy a tunnel, you might not be in possession of the land underneath. But the mudstone is the land underneath. That is all there is. It's the stratum. It's the same thing all the way down for 4 miles, so far as anyone knows. Same point, I suppose, might occur in relation to caves. I mean, if there's some sort of cave under there, we might not have manifested, we might not have been in possession of that. Doesn't matter. It's not about caves, it's not about limestone, it's about the stratum of mudstone that we have been in possession. It's all about the inference that can be drawn from what we've actually done, taking a practical view. The inference is that for 50 years, we have been using and controlling the stratum of mudstone under the forest as our own, and nobody else has been doing anything with it. If you use something as your own for 50 years and nobody else does anything with it in that 50-year period, it's rather hard to conclude that you haven't been in possession of it and someone else has. But ultimately, these are conclusions that the judge was entitled to draw from the primary fact she found. Now, ground 5 complains that the judge was wrong to find that roads and tracks had been cut into the mudstone in every forested area within the subject of the claim. Well, the evidence is in Bundle A, which consists of the official copies of the register. I'm not going to take you through them all, obviously. I just want you to see what the tracks look like. The first title, A1, the plans are A45. Forest, you need tracks that you can get the forestry lorries into. And that's not atypical.
You say A45?
I'm sorry, A5, my lord.
A5. Okay.
Oh, that's my fault.
So sorry, this is a plan of one of the registered titles.
Yes, this is claim A1.
Claim A1.
Yeah. Which is one of the A titles under appeal. That's what we've done by way of roads and tracks. Cut into the mudstone to use it for our forestry purposes.
Do we have any photographs? I mean, I can imagine what it looks like. I'm just wondering if anywhere in the bundle we do,
Yes.
as it were, typical roads cut into the side of a hill or something like that.
In the expert report, which I think is in Bundle C, there are some diagrams and there are some photographs.
Oh, thank you.
So
Just make it feel
Oh, bundle B, I'm told by my learned junior. So, if you go to, although it's very small, you can see at 207 a photograph of a road that's been cut into the side of the hill.
Yes, I see.
There are cross sections for building roads at 201 and 202, which show how they're built.
Yes.
So as you might expect, if they're cut into the side of a hill to go round the hill, you cut into the hill and you put the spoil on the downslope side. There's also, I mean, a better view of that, if you like, at 200. You can see how the road there in the right-hand photograph obviously been cut into the side of the hill.
Yes. Now, and these are obviously quite substantial roads, large enough for what a lorry to carry away a load of tree trunks.
Well, that's how you get the trees out.
Indeed, yes.
Big yellow lorries. So if you go back to the land registry plans, just to demonstrate that what I was showing you is not A2, land registry plans are in bundle A, supplemental bundle A. So A5 shows the tracks entitled A1.
Yes.
A10 shows the tracks entitled A2. A bit harder to see on A15, which I suspect is an older plan. Similarly, A23. That I hope gives a representative cross-section of what the judge was dealing with. And if further evidence was needed of that, if you go to supplemental bundle C, please, at tab 40. This is the cross-examination of Mr. Collins, the surveyor land agent for the appellant. Question, they don't appear on any of the old plans, do they? So we can infer they were put in for forestry. Yes. Yes, they've been put in since the land was forestry. And then back to tab 35. Again, this is Mr. Collins again. Lines 21. Machinery and equipment available to people today that was not available in the past. The density of the roads is not as vital as it was. The whole purpose of the roads is to reduce the cost of forestry and therefore increase the profit of running the forest.
I've got that. Which tab was that again?
And that's tab 35.
35, sorry, my fault. I went to the wrong tab.
It's lines 13 to 15 and lines 22 to 25.
Thank you. Yes.
And then tab 46. This is the appellant expert, Mr. Duncan, being cross-examined. Lines 7 to 13. And the ones I observed, by and large, they were cut into the roadside. Bear in mind also that many of the forest tracks are also cut into the side of the hillside. Therefore, they've been constructed on a cut and fill basis, and they've done the quarrying in exactly the same basis. They cut into the hillside by and large.
Yes.
And that's before you even look at our factual evidence of everything we've done about maintaining the roads and building the forest tracks over the course of 50 years. Because of the time, I'm not going to take you to them, but they're in the bundles. We've got Mr. Griffith's witness statement explaining that. That's bundle B, tab 20. Mr. Fletcher explaining how the roads were built. Tab 19 of the same bundle. And Mr. Wallace for the approximate amount of the area. It's tab 18. So essentially our point is plenty of evidence from which the judge was entitled to reach her primary conclusion. Not your job to interfere with that in any event. She's the fact finder, and you've only seen a fraction of what the judge had. And it is a perfectly rational and practical view, based on the evidence she heard and the concessions that were made in cross-examination, that we had taken possession of the stratum of mudstone more than 12 years ago. Now, all of this is in our skeleton. The cross-references to the evidence are in the restated skeleton in the bundle, so I'm not going to waste time giving your lordship the references.
Thank you.
That leads us on to ground 6, which is that it's an error of law to consider that planting trees could constitute acts of adverse possession? I don't know why the appellants think that planting a commercial forest can't be an act of adverse possession. And the judge used the facts, the judge used the fact that the forest had been planted between the roads and that the fact that the roots would go down into the stone to conclude that we had manifested an intention to possess the stone beneath the forest as well as beneath the roads.
Mr. Wynne-Finch, you've said that a couple of times. You referred us to paragraph 169, and I'm with you, understanding that the judge made a finding about the effect of planting between the roads.
Yes.
But I don't see anywhere in the paragraph, and you can help me, that it's got anything to do with the roots going under the ground. What I thought this was about is manifesting the intention that there will be disturbance when these trees have to be harvested in the gaps between the roads.
The finding that trees must in many places have encroached on the subsoil is in the previous paragraph, my old 168, penultimate sentence. But you're quite right.
I see.
When you harvest the trees, well, actually, it's not my role to give expert evidence. I'm not going to do that. The judge concluded there'll be a disturbance in the mudstone and subsoil in almost every case. And that an objective informed observer would appreciate that additional activity would typically be required for harvesting, if not thinning. And that was the evidence before the judge. And then by planting, we manifest the intention to take whatever steps needed to harvest in due course. An informed observer would be aware, be highly likely to require further disturbance to the subsoil and in many cases the bedrock. So that's taking the practical view about the locality over which we have demonstrated an intention to take possession of the substrata. Before I move on to land registration, my Lord Justice Henderson asked about the references to the asked about the pleadings in respect of the extent of the area where we pleaded adverse possession.
Oh, yes.
For your Lordship's note, the particulars of claim, it's core, tab 11, page 143, para 4. And the defence, it's para 8, core, tab 12, page 159.
Thank you.
Now, my Lords, I move on to the respondent's notice. This applies to only some of the titles, because when you apply for first registration of an unregistered title, the registrar looks at the deeds that you provide, and if there's anything which causes him to suspect that the mines and minerals have been accepted, he puts a note on the register to say that they are accepted from the effective registration. That does not mean that they necessarily belong to someone else. What it means is that they continue to be unregistered land. But if there is nothing in the the good root of title that is presented to him, he will not enter a note, with the result that no exception, that the mines and minerals are not accepted from the effect of registration. And we have 6 titles under appeal where either there's no such note or the note is in more restricted form and doesn't protect the Wynne-Stay estate. I'm just going to show you those because they are important. If you go to bundle A, alpha, tab 8, page 34, you can see entry number 2 on the property register is that the mines and minerals are accepted from registration only in respect to the part tinted blue. It's a western. If you're looking at the plan, my lord, it's quite hard to see because it's been photographed very well. But it's a triangle. It's the rectangle of land right on the western corner. The rest is cut tinted blue. Don't think it actually matters where exactly it is.
Sorry, the plan in question is the one immediately after.
Yes, the plan
36.
That's right.
I'm sorry, the bit I've got tinted blue is a long sort of serpentine.
Yeah, the long serpentine bit is tinted blue. The mines and minerals
Yes.
are accepted from registration for the blue bit, but not for the rest.
Yeah, so there's a little bit of land edged in red which is not tinted.
That's right. C13, A57. For most of this title, there's no appeal. There is an appeal in respect of the part which was correctly treated as an A title, but there's no exclusion of mines and minerals at all from this title.
I'm sorry, where are we?
A57, my lord.
A. Oh, page 57.
Yes, yes, sorry. Supplemental bundle A, page 57, tab 13. So this is title C13, it's tab 13, there's no exclusion of mines and minerals on the title. my lords, I could go through the other 6 cases. I suspect it'd be tedious for me to show you each title.
Yes, thank you. Well, that shows the pattern.
It shows the pattern.
Yeah.
Now, we rely on 2 principles of land registration to say that where there is no exception, or the exception is inapplicable because it refers to something else, the mines and minerals are part of our surface title. The first proposition is that registration of the surface includes every substratum unless there's a note on the title to the contrary, or unless the substratum is an overriding interest. And the second proposition is that a claim to a physical substratum cannot be an overriding interest as a manorial right.
Oh, sorry, it cannot be.
Cannot be an overriding interest
Yes,
as a manorial right.
thank you.
Just doesn't qualify. If you could go please to Authority Bundle 3, I'll show you the relevant provisions of the Land Registration Act, starting with tab 56.5.6. And if you go through 3 pages, please, to section 11, freehold estates. So, section 11, subsection 1, this section is concerned with the registration of a person under this chapter as the proprietor of a freehold estate. Registration with an absolute title has the effect described in subsections 3 to 5. The estate is vested in the proprietor together with all interests subsisting for the benefit of the estate. The estate is vested in the proprietor subject only to the following interests affecting the estate at the time of registration. Interests which are the subject of an entry in the register in relation to the estate. And I interject there, we've already seen in some cases there's an exception of mines and minerals. And when you've got an exception of mines and minerals, that's section 11.4a. And then B, unregistered interests which fall within any of the paragraphs of Schedule 1, colloquially called overriding interests. And then C, interests acquired under the Limitation Act 1980 of which the proprietor has notice. So if we have notice that someone has acquired a title by adverse possession against us, we take subject to that too. Schedule 1 is at tab 57. And these are the unregistered interests which override first registration. You see paragraph 7, coal mines and coal, statutorily vested in the Coal Authority. 8, In the case of land to which the title was registered before 1898, rights to mines and minerals and incidental rights created before 1898. So if first registration occurs before 1898, the mines and minerals are an overriding interest. In fact, there are only 5,021 such titles in the whole country, and ours aren't one of them. And then 9, in the case of land to which title was registered between 1898 and 1925 inclusive, rights to mines and minerals and incidental rights created before the date of registration of the title. Now, parts of London became compulsory registration areas between those dates. And so if you have a first registration of the title before 1925, then rights to mines and minerals created before first registration are an overriding interest and continue to be. Policy changed in 1925. In 1925, rights to mines and minerals ceased to be an overriding interest on first registration. And to make good that proposition, if you go forward to tab 60, there's a copy of the Land Registration Act 1925 by Sir Charles Fortescue Brickdale and John Stuart Stuart Wallace, both of whom were registrars of the Land Registry, one after the other. If you go over the page to page 13, they say, first new paragraph, under section 20 of the present Act, that's the 1925 Land Registration Act, the registered proprietor obtains an estate in fee simple in the land dealt with, together with all rights, privileges and appurtenances belonging thereto. Land includes mines and minerals includes any strata or seeming minerals or substances in or under any land, and powers of working getting the same but not an undivided share. By this inclusion of mines and minerals, this inclusion of mines and minerals is subject to an important qualification, namely that should it be proved that the mines and minerals have been severed and the register be corrected in consequence, the purchaser will have no claim to an indemnity out of the insurance fund. And that continues to be the position. You only get an indemnity out of the insurance fund if the register expressly says that the mines and minerals are included. Otherwise, they are presumptively included. They're included in your registration, subject to any possibility of rectification. And my learned friend read you a passage from a Law Commission consultation paper yesterday, stating that was the view of Professor Charles Harpen. What he didn't tell you was that Professor Harpen was the draftsman of the 2002 Act. Now, I know the draftsman is often the worst person to interpret what he's written, but it wasn't intended to make any change in 2002. Mines and minerals continue to be included in a registered title unless they are in that list of overriding interests. So we come back to the list of overriding interests at tab 57. Which see, paragraph 11 is a manorial right. You cannot tell from what has been printed here, but that was subject to a 10-year sunset clause. You had to apply to register your manorial right within 10 years for it to continue to be overriding, but the appellants did that. And so the question is whether any of their rights are a manorial right. Now below they sought to argue that they were. I didn't detect my learned friend trying to argue that they were here. And they're not, because manorial rights bears a very narrow technical meaning in the Land Registration Act. Now, it's fully explained in our skeleton. It'd take me at least an hour to go through if I was going to go through it, so I'm not. I'm just going to take you to the Law Commission consultation paper, the Law Commission report that makes good that point, which is a tab 61 of this authority bundle.
My lords, we're not arguing.
Oh, that's very helpful. It's conceded it's not a manorial right. You don't need to worry about it.
Save an hour.
Thank you very much, Mr. Moran.
Instead, the new point yesterday was, oh well, we can get rectification. Not quite as simple as that. The first and most obvious point is that they haven't done so. And they're seeking a declaration about what their rights are now, or more actually were at the trial, not what they hypothetically might be after an application for registration. No pleaded claim for rectification in this claim. Which brings me to the second point, which is that where a right to rectify is disputed, it doesn't just get dealt with administratively, it's litigated out in the first tier tribunal. The reason for that is if you object to rectification under section 73, it gets the claim gets transferred under section 108 to the first tier tribunal to decide the validity of the objection. And we're going to be taking a Henderson point there, obviously. And then if they get over that, I'm a proprietor in possession. My title is one title to the surface and everything underneath. And you can't rectify against me unless I've caused or contributed to the mistake by carelessness or fraud, or there's some similar reason why it'd be unjust to refuse rectification. What are they going to say? That I should have realised that there was an Enclosure Act in 1816 that gave them a title under an award to the entire subsoil? I'm afraid at this point, unpleaded, far too late, and doesn't provide a solution to their problem. My friend said, I'm not a proprietor in possession because I'm not in possession of the minerals. I am, there's one title. I'm a proprietor in possession of the undifferentiated surface and everything underneath, because that's what the effect of registration. And it said, oh, well, that's unfair. The whole purpose of registration is so that we don't have to conduct this kind of legal archaeology facing ransom claims over mudstone based on fiefments from the 16th century and early 19th century enclosure acts. Entirely fair. It's the policy of registration.
To create certainty, you just have to look at the register.
Yeah.
And if you want to revive one of these historic claims, you better get registered first. Now, I've been told off for not giving you the references to the page references to the 6 titles where this applies. So I'm just going to do that. The page references, they're all in bundle A. They are 34, 57, 71, 170, 175, and 185. And then finally there's the question of the form of the order. Could I ask you to go to the core bundle, and you can see what it is that the appellants are asking you to do. This is tab 1, page 6.
Tab 6.
No, page 6, tab 1, my lord. It's the appellant's notice.
Oh, yes, sorry, beg your pardon.
Seeking set aside the dismissal of the claim and a declaration as to ownership of the reserved material. They haven't set out the order they're asking you to make in respect of remission. And there are real problems with that. There are 9 locations where the appellants claimed that we were extracting material we shouldn't be extracting from. Which of those do they say are included on the titles in this appeal? Because there are genuine mapping issues that they didn't deal with below. They were asking below for damages and an account. Well, you can't have both. It's a common law claim. If you want an account, you waive the tort by adopting the acts. What do they want? Damages or an account? I have to say, it seems pretty silly to us to ask for an account since we haven't made any money out of this. We just use it.
Hold on a minute. There's nothing about either damages or an account here.
No, but there is in the claim form, and what is being asked for in the skeleton is that it be remitted for a quantum hearing to decide that.
Yes, and at that point they would have to elect.
They would have to elect now whether they want a judgment for damages or whether they want damages for an account, because this would be the final judgment.
No. The usual way is that if you have a trial on liability, which gives rise to the alternative financial remedies of damages or an account, post the decision on liability, the claimant must then elect which of those two remedies he wishes to pursue.
He must do that when the judgment is drawn up.
No, absolutely not. Indeed, in the intellectual property sphere, which my Lord and Justice Birss and myself obviously have most experience of, the way it goes is as follows. First, you get your judgment on liability. Secondly, you get some limited disclosure to enable you as proprietor of the IP rights to make your election, and then you elect, and only at that point do you bifurcate down the roads of damaging inquiry or account of profits.
Well, I've been brought up in the property world, and in the property world, where you have to elect between affirmation or forfeiture, you have to do it when the judgment is drawn up. But it's a small point, it doesn't matter. It's payment and langiani in the property world. We're not going to make a terrible fuss if you decide that they can elect later.
I mean, this is, if we get to the stage where this becomes relevant, it's a very technical objection.
It is. But perhaps a less technical objection is limitation's a matter of liability too. And we need to know what it is they say the judge should have decided about limitation. But none of this is in the appellant's notice. There's no clue about the order that's being sought. What is being sought is to send it back for a blank check, with a blank check for a quantum hearing, so that they can cure the deficiencies of their mapping evidence, which they should have led at the liability trial and didn't.
Yes, so that's a completely different point, as I understand it, to the point about damages or profits. Your point, I think, if I've understood it correctly, is what's being asked for at page 6 is a blanket declaration in circumstances where you say the evidence at trial didn't justify a blanket declaration.
And what isn't being sought is remission below for any further hearing. And if remission below for any further hearing is being sought, the terms of that need to be stated. Well, we hope.
So, and to be clear, would you suppose we ever got to this stage?
Yes.
Obviously, we have to cross a number of hurdles before we do get to this stage. But assume against yourself for the moment we do cross those hurdles and we therefore do get to this stage. Would you resist a remission upon terms that prevented the appellants from adducing any further evidence?
Oh, no, of course not.
Right.
And indeed, they'd be entitled to adduce evidence of quantum and value. What they're not entitled to do is to cure the deficiencies of their mapping evidence so as to say this particular extraction took place on this particular title.
So if it was on terms that there was to be no further evidence save on matters of quantum and value, that would meet your point.
We'd also have to deal with limitation.
Sorry, and what's the limitation?
How far back does the claim go? We say 6 years. That's a liability matter, that is not a quantum matter.
And was that argued before the judge?
Yes, it was.
Sorry, I can't remember now whether she deals with it.
She didn't, no.
No.
But it's for my own friend to say she should have dealt with it and she should have said, my claim is good for this particular period.
Well, I mean, having rejected the claim anyway, I suppose from one point of view it was academic.
But it's academic for her and us, not academic for my learned friend seeking a remission for a quantum hearing. It was a matter of liability. He has to say what order the judge should have made in respect of limitation.
I mean, if it was...
My lords, we may never get there, but that's the point.
Can you just enlighten us, what were the rival positions on limitation before the trial judge? You've just told us that your position was 6 years. which is understandable. What will the claimants say?
I'm not sure, is the answer.
What? Sorry, I thought you just told us it was argued at trial.
We argued for a 6-year limitation period at trial. I'm not sure what period the claimant was contending for. I'm not sure we ever got an answer.
I find that a little baffling, but there we go.
Well, I must say, against that background, if that is the case, it would seem, if we get to this point, and I don't want to spend too long on this, the sensible thing really might be to remit that issue for the judge to reach a conclusion on now that it's material.
I'm not going to go to hell in a handcart over that point.
No.
there are better points. One thing I forgot to mention on category C, that is the relevance of the minerals review. Well, the minerals review happens in 2012. That's long after we've acquired our title by adverse possession. We start adversely possessing in 1970. And on the limitation point, that's dealt with at 173 of the judge's judgment, where she concludes that there'd been no deliberate commission of a breach of duty. So 173 to 179, which would seem to imply that the limitation period ought to be 6 years. I don't know when it's being said, it ought to be something else. And as you can see at 174, she says, point wasn't developed in oral submissions, nor relied upon in seeking to cross-examine the defendant's witnesses. So that was the state of the limitation argument below. As I say, we may never get there.
You probably rather hope we don't.
I certainly do, yes. Well, I think I've taken up not quite all my time, but I've said as much as I wish to say. It may be that my learned junior would like to follow, because I often miss points that perhaps ought not to be missed. Unless you've got any questions for me, those are my submissions.
Well, let me first see if we have any further questions for you. I think we don't. So, Miss Holmes, do you wish to follow on anything?
No, thank you very much, my lord.
Very well.
My lord, very quickly, just while it's fresh in everybody's mind, dealing with the form of order. I don't think this is going to be a big issue, clearly. What we're actually asking for is damages with an account of the reserved material wrongfully extracted and an account of capital and income receipts. It's not you're taking the money off it. It's an old form of relief. And the reason that we use the term account is it goes into effectively an accounting inquiry. But I don't think this is going to be a hugely practical issue. The other point about limitation is a defence. It's not dealt with in the judgment. It is, strictly speaking, for the defendant to raise it by means of a respondent's notice. We're obviously not going to oppose the point being raised again on a remission. I've quite a few points to go through in reply, but they're all, although there are lots of them, they're all relatively discreet and brief. Starting with the Type A conveyances. There's one overarching problem with my learned friend's submissions on the Type A conveyances. He said at the outset of his submission that conveyancers, back in the Victorian era, knew that wide words such as stone or minerals would be cut down by, I think he said the courts, cut down on interpretation. And that's simply wrong. They would have known that minerals would be cut down because there was plenty of authority on that, and it was a well understood term of art. They would not have known that an ordinary word stone would be cut down by the courts, and there is no principle that wide words would be cut down. He then went on to explain why stone would be included as an express provision in the Taipei reservations. And he went through the history of the Scottish case that then got picked up in 1888 in Glasgow against Fairey. And he concluded or submitted that at this stage, conveyances would be including stone to avoid its exclusion as being a material that is not coming out of a mine. The etymological derivation of the word minerals meaning out of a mine. But on that basis, while minerals might be limited, why minerals might be reduced in its meaning, it still doesn't explain why stone would be reduced in its meaning. And interestingly, all that tends to indicate is that stone would be something that people were interested in. Now the phrase, or the word stone, was included because of the decision in, bear with me, Lord Breadalbane and Mingus, where the words hail, mines and minerals of whatsoever nature or quality were not held to include a vein of stone suitable for building. And that, in our submission, simply tends to emphasise that what we have here, the mudstone, is included in the reservation stone. Because this material, we say it's unambiguous, but on any basis, in this particular factual context, in this particular factual matrix, mudstone was used for building, both infrastructure and cottages, as well as roads. It was the common stone of the district. So even in context, in this case, mudstone is still stone. And if I can take your lordships to the Glasgow and Fairey case, which is Authorities Bundle 1, tab 6. Now, just to refresh your memories, at page 672, you've got Lord Halsbury's, the Lord Chancellor's passage starting at the bottom of page 672, talking about Lord Breadalbane and Mingus. That goes from 672 over to 673, and that was a passage that your lordships referred to yesterday by the learned friend. And this is in the context of a Canals Act, the Waterworks Act. Now, if you can turn on to page 689, you get quite an interesting comment by Lord Macnaghten. 9 lines down, beginning expense to do so. If the intention of Parliament had been to reserve to the vendor, under the exception of mines, all minerals of any description, however they might be worked, and therefore such thing as clay, stone and gravel, which are ordinary materials for constructing or repairing the works, one would have expected to find the undertakings and the company authorised to use not merely such part of the mines as might be necessary, but such parts as might be useful or proper for constructing their works. Now we know here that stone was used for building infrastructure for mines in the region. In this context, even if you can say that the word stone is ambiguous, mudstone falls within it. Next point, category D. But then a friend opened his submissions on category D by saying that the reservation of minerals was non-standard in enclosure. With respect, that's evidence from the bar. What your lordships have is Wayneman and Ross with an extremely similarly worded reservation. Your lordships have Micklethwaite and Winter. And your lordships also, whilst you have Glasgow and Faery before your lordships, have a further brief reference but explanation at page 667, explaining Ross and Wayman. And this is in submissions with a little interjection by Lord Halsbury. And the submission is previous to the Lord Works Clauses Act, Lord Wensleydale and Ross and Wayman decided the word minerals was not to be understood in its general sense, signifying substance containing metal, but in its proper senses, including all fossil bodies, all matters dug out of mines, and the mines, according to Jacob's Dictionary, are quarries or places where anything is digged, and therefore beds of stone, which may be dug by mining or quarrying, are proper minerals. Lord Halsbury. That was a Lord of the Manor case, and the fact that the Lord had a right to everything under the surface was the foundation of Lord Wensleydale's judgment. Fine. This is a Lord of the Manor case, and the Lord of the Manor had a right to everything under the surface. And then that's further supported in the case of Consett, which your lordships have already been taken to, on the interpretation of Enclosure Act. Now, yes, obviously every Enclosure Act does have to be interpreted on its own words. But the principle is that if you've got a similar enough Enclosure Act, they should be interpreted in like terms. And here we have a similar enough Enclosure Act, a similar enough reservation, to be interpreted in like terms. And whilst one is in this time zone, in the context of Enclosure, one then has an example given in the Upper Elkstone Act. Now this is in Authority Standard 2. I think it's 4 years before our particular act.
Sorry, which tab is it?
Sorry, tab 23, my apologies. Tab 23.
23, thank you.
Upper Elkstone in the county of Stafford. 1812 to 1813. Interesting, the first page, it's a rather peculiar one, and you can see the variations in drafting of these things. The second paragraph mentions that the most noble William Spencer, Duke of Devonshire, is or claims to be Lord of the Manor. It doesn't actually say, and thereby entitled to the soil, etc., but it then goes on. And then you turn to page 22 of that act. And you get this interpretation, this reservation clause, which reserves, together with powers to dig for, search for mining, etc., mines of lead or copperal, mines, veins, beds, or seams of coal, ironstone, and other minerals, brackets, save and except stone, gravel, clay, and sand. So exactly, strikingly similar terms to the one used in Glasgow and Faery as to the sort of materials used for infrastructure building. Not necessarily, in and of themselves, particularly marketable in a wider market, but valuable to the occupiers of the land. But what that tends to indicate is that if you wanted to exclude that sort of material, a draftsman might do so. And they did not do so in our case. Now, turning over the tab.
So just before you leave
Yes.
that exclusion, one of the things that puzzle me about it is how does it work with ironstone being, dare I say it, stone, the clue being in the name ironstone?
So, which I will be coming back to. There's a principle
We'll
that,
come
no,
back.
it's a very simple one. There's a principle of construction of statutes, which is where you have a general term and a particular term, the general gives way to the particular. So if you have a reservation excluding stone, which is a general term, but you include ironstone, which is a particular term, your reservation includes the ironstone, which effectively trumps the more general stone. So because ironstone's a subset of stone, you can carve it out and include it in the reservation while excluding from the reservation other stone.
Okay.
And you can see that principle actually in tab 30. The case is Pretty against Solly.
Now, this isn't a case that I went to or my learned friend went to in opening. It's not a matter of reply.
Well, it is a matter of reply.
Well, if it is a matter of reply, you certainly have a right to come back on it afterwards.
So
In what sense is it a matter of reply?
it's a matter of reply because when my learned friend referred to clause 37 of the Arrestley Enclosure Act, Rights of Tilbury, you have and referred to the fact that there is a general reservation for stone. Thereby everybody got stone, and the question is, but they didn't get the soil or any other matter. The answer to why the reservations for Tilbury, the allotments for Tilbury, isn't a problem for the reservations of minerals, is that because you have a specific or particular allotment for stone, as opposed to a general reservation of minerals, the particular, in that case, the particular reservation trumps the general. And you can, first of all, that's a matter of just a principle of construction of statutes. Secondly, it's in Pretty and Solly. I'm relatively certain my learned friend isn't going to challenge the idea that the particular trumps the general in statutes. But maybe.
Well, and it's just a general proposition often expressed in a Latin phrase about generalities not detracting from particulars. Does it come to any more than that?
No, not really, but it works that way if you have a particular.
I mean, it's only a guideline, like all these things.
Absolutely. And it's described in the passages in Pretty and Solly, tab 30, page 1034, where the Master of the Rolls, Sir John Romilly, says, in his second paragraph of his judgment, the general rules which are applicable to particular and general enactments in statutes are very clear. The only difficulty is in their application. The rule is that wherever there's a particular enactment and a general enactment in the same statute, and the latter, taken in its most comprehensive sense, would overrule the former, the particular enactment must be operative, and the general enactment must be taken to effect only the other parts of the statute to which it may properly apply. I mean, it's common sense, if nothing else.
Well, as a rule of thumb, it may be common sense, but like all such rules, it may yield something different in the context.
Absolutely. So that explains clause 37 slightly varying provisions. That's the Rights of Tilbury, clause 37. My learned friend pointed out that minerals reservations were under the wastes, but not under wastes and commons, and I think that he acknowledged that given that wastes includes as a subset commons, that's not of any effect. And it does appear to just be, if anything, a minor slip. My learned friend also took your lordships to the allotments and showed that a number of allotments were on the edges of the town, of a town, and included cottages. Well, if anything, those allotments that include cottages are of particular value to the occupier. Because if that was an allotment of wasteland and commons land, those cottages would have been held on a very tenuous basis. If they were truly waste or commons land, then they weren't owned by anybody other than the Lord of the Manor. So whatever position they had, whatever title these people had in it, it's highly tendentious. So it's not odd that these people would have been exceedingly delighted to get a full title to those cottages and their land. And if they were on the waste and commons, they would have been subject to the Lord of the Manor having rights to anything underneath them. And the fact that they're getting a good title to the actual surface and cottages is more than sufficient reason for them to accept that they continue to have the Lord of the Manor having rights to what's underneath. Your Lordships were also taken to the terms of the actual allotment, the terms of the conveyance by the Commissioners, which refers to lands and grounds. The answer, the reason for that, as far as one can tell, is that lands and grounds is the words used in the 1801 Act. You're marrying up with Section 14 of the 1801 Act. There's nothing special. It doesn't indicate anything particularly interesting. So that's the Category D title. Category C title. Mr. Wanacott, in particular C17. Mr. Wanacott said that it was pleaded as an A claim, pleaded as a C claim, so there was no expert report on the substances in the ground. Well, that's not actually accurate. If you look at what the expert gave evidence on, which is in the Supplementary Bundle B, tab 24, so tab 24 is the Defendant's expert report by Mr. Sherratt. You can see that at page 177. For reference, tab 25 is the Claimants' expert report, which is page 243. And Your Lordship, my Lord Justice Henderson was asking whether or not there were photographs of these things. This is the primary source of photographs in this particular report.
Yes, thank you. I also look at that.
If Your Lordships turn on to page 179, you'll see that paragraph 1.2, it explains in summary the claimant's case in 2016 they became aware that NRW in disturbing reserve material, which is defined in item 4 of the particular claim as follows. The claimants are entitled to hold the ownership or alternative sole right to extract all minerals and other substances, etc. of the reserved materials. I'll come back to the POCs to show what that covers. And then, if you so that's what he was dealing with, and you have the expert evidence thereafter, which goes into the roads, as well as the quarry inspections are at internal page 34, and you will see page 212 of the bundle. I'll draw your attention to the paragraph 10.1.1. Quarry specifically referred to the particulars of claim include as follows, and I'll draw your attention particularly to Nanty Quarry and Aerospace. And
I'm sorry, to which one?
Sorry, the first bullet point and the last bullet point at 10.1.
Oh, I see,
Nancy
sorry.
and aerospace.
And aerospace, yeah.
And then if you turn on to page 217, you'll see the quarries, paragraph 10.2.2, the quarries were inspected after the installations and in the following order. Installations were the telephone mast. And you'll see the bullet points, the third from bottom and second from bottom,
Yes.
aerospace and Nanty. Now, the reason I've highlighted that is if you close up supplemental bundle B and turn back to the core bundle.
Sorry, back to...
Sorry, close up supplemental bundle B, that one.
Yes, sorry, you then said something after that, I thought.
And then turn back to the core bundle.
Core bundle.
POCs are at tab 11. Amended particular claim, strictly speaking. And paragraph 4 at page 142 explains they're entitled to hold the reserve material. And then at paragraph 6, reserve material tinted green, tinted blue, and then 7 tinted blue, paragraph 8 tinted yellow and purple. But the really useful and important bit for this is if you turn on to paragraph 11 at page 145. You see paragraph 11, in particular without prejudice, there's been A, extracted reserve material as follow. Little 1, anti-quarry, and then B, entered into arrangements to permit the reserve material to be used for the purpose of field testing facilities for explosion studies at aerospace quarry. And then Nanty and aerospace again, and then if you can turn on to the schedule to the POCs, which starts at 150, but in particular 13, page 152, 13 and 14. You have item C13, C14, land including Nanty quarry, and then aerospace quarry. Now, aerospace quarry in particular, but the whole point is that the evidence of the expert for the defendants covered all the titles, including all the quarries and roads across all the titles full stop. So it's not accurate to say that there was no evidence as to material within those titles. There was. I have absolutely no doubt that the defendants were going to raise an appropriate point, and did raise an appropriate point, that even if these things had been reserved, it wasn't a reserved material. Sorry, mudstone was not a reserved material. The extractions were not a reserved material.
I may be missing something, but can you explain to me why you rely upon Nanty quarry and aerospace, which are, as you've just said, C13 and C14, when the one at issue is C17, which doesn't include Nanty quarry or aerospace?
No, it was to explain that there was evidence obtained as to the materials in the C titles. And the argument, the point taken by my learned friend was this was put forward, this was pleaded as a C title, although it's acknowledged that it's an A title. And in fact, there was no evidence as to what the materials in the grounds was. This was the one with the cliff.
Well, I can understand why there was evidence about the quarries. That doesn't seem very surprising. It seems just because there was evidence about quarries, it isn't obvious to me why anyone should have thought they had to go to McCunliffe C17 to find out what was there. It wasn't a quarry.
Well, it was roads as well.
Yes.
But it was roads across all of the titles. It wasn't as though there wasn't evidence of what the material was. If there had been some sort of C17 or C13 or C14 was somehow a different material, not mudstone, that's where it would have been coming up from. The argument was that they weren't adducing evidence to these titles. The answer is they were. Turning then on to adverse possession. It sounded very, very strongly as though my learned friend was saying that they had adverse possession of the mudstone all the way down for 4 miles. There's not a respondent's notice on this. And the judgment says that if there was adverse possession, or if we had reserved materials, then adverse possession would have been of, and this is judgment at paragraph 194 of page 127 of the core bundle. 194 sub 3. If the conclusion at 2 above is incorrect, mudstone is a reserved material, then the defendant has established adverse possession to the mudstone, including interbedded sandstone and shells as above, to whatever depth might be required for activities undertaken by the defendant as surface owner of the relevant forested area. That's not 4 miles. That's whatever depth is necessary as owner of the surface.
Why does it matter?
Yes.
Well, I wanted to make sure that there wasn't, in fact, going to be some claim put forward or falling into a judgment from the Court of Appeal that there's adverse possession of 4 miles down if we want to dig under at 100 metres, for example.
What, you're entitled to take your stand on what the judge actually found, as
Yes.
you rightly pointed out, there's no cross appeal.
Yes, exactly. That's the point. I didn't want it to slip into a judgment accidentally. More substantially on the matter of adverse possession. My own friend accepted there was no intention evidenced or evinced outside of the forested area. There are 2 points that come out of that. First is he went on to say all the land, all the titles in question, was used by the Forestry Commission as part of its statutory function to promote forestry, and all of it is forestry land. That's not the case. There's certainly no finding of fact of that, and were that to come up at any stage in the future, we would dispute it. There are, in fact, portions of the titles which are not forested. More substantially, that identifies what we say is inevitable from the judgment, if nothing else, that one construes the intention of a surface owner extracting minerals by reference to their surface title and their surface activities. And if that's the case, then it's far more limited in how far it could be said that there's a common characteristic of the locality. And with that basis in mind, you again turn to the matter of degree, and my learned friend pointed out the passages in the judgment as to 15% of the forested areas would be roads. I'd just remind your lordships on this, that finding of fact is, if you look at the evidence, you have to be quite careful about how you read that 15%, because it includes verges and the like. It's not actual digging.
I mean, the judge will have had that well in mind.
Yes,
So,
I'm highlighting the fact that it's not 15% of the surface dug out.
that's understood, but it does mean an area amounting to roughly 15% of the total was used up by roads and
spaces around it.
spaces around them, which you would expect to find by any road. I mean, obviously.
But again, it comes back to the question of how much of that material, subsurface material, could have possibly been extracted, and how much of that is use of the surface by reference to, or use of the subsurface by reference to the surface.
But once it becomes a question of fact and degree, I mean, that is then quintessentially a matter for the trial judge, is it not?
Well, again, on our appeal, we say that if by the time you've got roads like that, it is simply implausible to extend that to 100% of the forest area.
Well,
Thousands of acres on the basis of limited strips of road.
what do you quite mean by implausible? Are you saying it's impossible as a matter of law, that the finding was...
We say that that was an
insupportable?
improper finding as a matter of law. And that's our...
Yeah. I forget which is your
ground
grounds.
4-2 and ground 5. Well, ground 4-2 fundamentally.
Yeah.
And it's worth noting that Maloney Friend flagged up the case of the 92 acres, you nibble at 2 acres, of course you don't possess them all. It's basically at that level. It's at, the 15% is more than 2 out of 92, but it's approaching that level.
I mean, just everything depends on the facts.
Everything
Really.
depends.
I mean, it all depends how the 15% or 10% is divided up, how it relates to the ground as a whole and what it's being used for. And it's not enough just to say a percentage that of that size cannot,
No.
in any circumstances.
But
if
in
it
this
was
particular
intentional.
case, we say that would be inappropriate.
And it's not just that, it's that combined with the planting of forest on everything else.
That's my next point.
All right.
How is planting trees stopping us exercising our rights to the minerals? Because let's say there were no buildings of no extractions of stone whatsoever, and they just planted trees across the entire area. Or let's say they planted corn. It doesn't stop us coming in and exercising our rights of access. We just come in and say, well, we've got a right to do this, and we've got to pay you compensation. It doesn't prevent us. If there were lead mines discovered, or coal discovered a mile down, the fact that they've planted trees wouldn't stop us. We have the right to extract.
If you had a right not to break up a piece of mudstone 2 meters underground, and the tree breaks that mudstone, then it has interfered with your right.
It may have done some damage to one of our properties, yes, but it's not. The fact that it's there isn't going to stop us coming in and breaking down to mine to it. That's a very different matter as opposed to controlling that mudstone.
Well, it does, because what your right is a right to get a nice, big, solid, beautiful piece of mudstone to go and build your house, or put in the National Gallery or something. You can't do that because their blessed trees have broken it up.
It's damaged it. It hasn't possessed it. It hasn't controlled it. Rather like if you're
Treated
if my
it
tree
as
on
you
my
would?
ground.
Treated it as an owner would.
No, if I've got a tree on my black acre next to the fence with white acre, where you've got your house up to the edge, and my tree, the roots go under and damage your foundation, that's not a possession of white acre. That's damage to white acre, but it's not a possession of white acre.
Okay.
And so it hasn't interfered with my possession of it.
Doesn't it depend what your possession is of, though?
It doesn't interfere with possession because possession is, as my learned friend pointed out, different from occupation. It doesn't interfere with, and it doesn't, more to the point, if and to the extent that that root has broken up the mudstone, it's broken up that bit of mudstone. It hasn't prevented any other bit of the mudstone being touched. And it's not about whether or not it's damaged it, it's about whether they've possessed it. If that were a basis on which you could have adverse possession, you'd have adverse possession of everybody's boundaries, left, right and centre, because their grass had roots tripping across, or their trees had roots tripping across. That's definitely not how it works. And for a start, it's not a human action. And even digging it in, you put it in the ground, it might not. It's not an adverse possession.
I'm trying to not have a dialogue with you, Mr. Moore.
Yes, my lord. It's a fun dialogue. I suppose the answer to this particular point is, if you have to be evidencing an intention, at the very least, the trees is an equivocal action. That's not enough.
Sorry, I didn't catch that last
If you have to
sentence.
be evidencing an intention, planting trees is an equivocal action.
Thank you.
And in fact, we would say it's no way an action, but if one concludes that it might be an action of possession, then it's an equivocal action. That is insufficient.
Yes.
And and that comes back to one fundamental problem, which is if you are using land in all the ways an occupying owner of land can use, and it's forestry land, and if your actions are still equivocal in relation to the subsurface, it's not enough. So when in Pye and Graham there's that analysis of how do you assess whether or not there has been possession or control, it says in general, I think the phrase is in general terms, or broadly, or usually. It's not an absolute test. And it is a problem with subsurface solids. How does surface action, even how does extractions on one place, indicate exclusive control of a solid material elsewhere? And the reason that we highlighted the cases flagging up non-user, owner of a minerals may not be digging them out for years at a time, is not to do with the intention of the owners, not to do with the intention of the paper owners. It's to flag up there's a difficulty with how people use subsurface minerals, paper owners or squatters. They just don't get used for a long period of time. And the defendant characterised our arguments as, how can I eject you from a solid? No, we said, how can you possess a solid so that I can eject you from it? That's the point. Let's just take a moment to take instruction. Well, that's all the points I have in reply. Is there anything that I can further assist you with?
Let me look to my right and my left. I think not. Mr. Miranda, thank you very much indeed.
Thank you, my lord.
Mr. Wonnecourt, do you want to come back on pretty, whatever it was?
Pretty and solid. Well, why not? It's bundle 2, tab 30.
Not compulsory, if you have a right to decide.
No, I won't keep you for more than 2 minutes. A word of warning about this case. Decided by Sir John Romilly, who of course was the Master of the Rolls who decided Checkley, that was disapproved in Bunticle. But I don't actually criticise the judgment, because if you go through to 1035,
Sorry, can you remind me where it is?
Yes.
yes, it's tab 30, my lord.
Which bundle authorities?
In bundle 2.
Bundle 2 is under my nose, probably. There we are. Yes, sorry. 1035.
1035. The issue was whether the mineral reservation applied to the whole of the land enclosed or only some of it. But what I rely on, which depends on the 58th section of the Act, the first new paragraph is what I rely on. He says, I cannot, however, see anything to limit this 58th section, and I think so the more from the peculiar use of the word soil. Prima facie, it would include everything above and below, but the word soil is used throughout this land as a distinct from that. And that's just for the proposition that using it to mean the topsoil is a peculiar use. I was also accused of giving evidence from the bar about the usual practice in Enclosure Acts. I said that there wasn't that the absence of a mineral reservation was a usual provision, because it was omitted from the 1801 Act, which set out the provisions that were usually included in Acts, did so expressly.
Thank you. Well, thank you. Sorry.
Sorry, I was just going to say I've got one practical point to say.
Oh,
We've got you copies of the maps,
well, that's very kind. Thank you
and
very much.
we will be arranging for transcripts. Do you need them in the next couple of days, or would the next 10 days help? There's a difference in price. I mean, if it really is going to help, we're fine with the next couple of days. It really comes down to your diaries. If you've got days booked out for judgment writing, we'll get it in the next couple of days.
Well, I mean, it so happens I will be judgment writing next week, but I have a lot of judgments before this one to get to work on. So I don't.
Perhaps if your lordships have to look at your diaries and get back to us.
Practical terms.
Let us know.
Very well.
I'll send these up to you by your clerk after you.
If you could, that would be very kind. Thank you. Well, it remains me to thank you all very much indeed, and obviously your respective instructing solicitors and teams for your very interesting submissions on this unusual and very interesting case, which we will take time to consider, you won't be surprised to hear, and we will let you have our judgments in due course, in the usual fashion, which is, again, I'm sure you're both well aware, will mean circulating it in draft, with an invitation to correct typographical and other obvious errors, but not to begin re-arguing matters again. And we hope you will be able to agree consequential matters. To the extent you can't, we will invite written submissions, which we will deal with on paper, unless we notify you to the contrary. And hand down will, well, it'll either be remote or in person, but no need for any attendance either way. So I think with repeated thanks to all of you, that concludes this hearing.